All right, hello everyone. Here we are, the last 3240 lecture video. And today we're going to be discussing licensing. What do I mean by this? So, something that you need to consider when you are building your software is that there are going to be certain legal issues that emerge. You're going to have to worry about licensing, contracts, insurance for your software, such as maybe liability insurance if something goes wrong. You're going to need to worry about what kind of end user license agreement are you going to have? EULA, end user license agreement. You have to worry, is there some data that has to be protected? Does it need to be FERPA compliant? Like if it's dealing with students, for example, or HIPAA compliant, if it's dealing with, say, patients or with health records. What kind of contracts do you need for incorporating your startup and internship? Entrepreneurship. This is something that you're gonna have to be aware of if you're trying to commercialize some startup product. What intellectual property, copyright, trademark things do we need to consider? This is what we're gonna mostly focus on today, and we'll talk about this as well. But the two are linked. How are you gonna do human resources? The employees that work for you, etc. All the what kind of contracts are your employees going to have, etc. All these things matter. We're going to focus primarily on intellectual property, but just be aware there's a lot of legal issues to getting software to market before you can start actually selling it. And first, let's talk about copyright, because copyright, of course, matters here. Copyright is actually a right that's enshrined in the U.S. Constitution. It is in Article 1, Section 8. So pretty early in the Constitution, in fact. And the idea is, in order to incentivize people to develop new scientific techniques or new artistic outlets or anything of that nature, they create an exclusive right. When you produce something, you have an exclusive right to that thing for a set period of time, where only you get to sell it. And so this creates a financial incentive to produce new works. So, how does this relate to software? Well, you may be thinking, if I buy software, it's mine, right? I bought it, so it's mine. No. Right? If I buy Stardew Valley on my computer, which I have, I don't own the software to Stardew Valley. I am licensing the rights to play Stardew Valley on my computer. I don't own it, though. Same way that if I buy this copy of Luigi's Mansion on 3DS, which, by the way, is a physical cartridge, right? This isn't even a digital download. This is, like, here's the actual Nintendo DS game. I own... Wow, it's not coming out, is it? There we go. I own this cartridge, but I don't own the software that is on it. The ownership of the software remains with the software company. And part of the agreement that I make when I buy a particular product is that I'm agreeing to the end user license agreements of that software. And there can be a lot of terms in this end user license agreement. A very common term is that you're not allowed to reverse engineer the software. That is, take the software and try to generate the source code of that software in order to then be able to modify it, say. A famous end user license agreement is the iTunes end user license agreement. And if you ever get an update for iTunes, it's pages and pages and pages, and no one reads it, and they just scroll down and click accept. And on there, you promise that you will not use iTunes to help create nuclear weapons. This is true. You promise that you will not use iTunes to create nuclear weapons. And so, if you use iTunes to create nuclear weapons, in addition to running afoul of many international non-proliferation laws, you're also at risk of getting sued by Apple and having your rights, your license to the iTunes software, to be revoked. And then you're going to have to use Google Play, and no one wants to use Google Play, right? I use Google Play, but nonetheless. Now, there is kind of an exception, I should note, to the reverse engineering clause. Technically, DMCA does allow you to reverse engineer software if it is specifically for the purpose of achieving interoperability between computer programs, but you can get into definitely a gray, legal murky area there, and if you plan to distribute any software like that, you're gonna run into some difficulty. So, now let's do a little bit of a history lesson. So, in 1983, the GNU Project launched, and the purpose of the GNU Project was to create a free Unix-like operating system. Now, what do I mean by free? Let's stop a moment, because we're talking about free software. You may think, oh, well, free, that's a simple, that just means no price. It's not what it means. So first, the free software movement, it doesn't use the definition of free you might be thinking of. The free software movement is not a bunch of hippies out there saying, man, software shouldn't cost anything, man. It's just the man keeping us down, charging us for software, man. The free software movement fully recognizes that people who are writing programs need to make money on those programs. Like, I like to eat and feed my cats and stuff, right? Like look at those kitties over there. Don't they just look like they're half starved to death? And if I have no money to feed them, what's going to happen? So, free software does not mean no price, because there's two different definitions of freedom. There's gratis, free beer. You don't pay for it. You get it, you don't pay for it. And then libre, lack of restrictions. So that is free speech. So you have a lack of restriction of what you are allowed to say with your own speech. Our Constitution does not allow people to place legal restrictions on your speech. That is a freedom in that sense of a lack of restrictions. And when we're talking about the free software movement, we are talking about this. So for example, you can have free software that costs money, and you can have software that costs money, software that costs no money that is given to you but is not free. You know, go on any video game buying platform and you will see tons of free to play games. But those games invariably are almost never free software. They're software at no cost. You still are restricted in what you are allowed to do with that software. So when we're talking free software, we mean that you can do whatever you want with the software. You can run it for whatever reason. You can copy from it. You can redistribute it with changes, although there are restrictions on redistribution still, but you can redistribute it. You can study the software. You can change it. You can reverse engineer it. You can improve the software, add your own additions to it. You know, I'm not allowed to go into this copy and make, say, a ROM hack of Luigi's Mansion, which is a different map. People do it, but, you know, I'm not allowed to, according to the end-user license agreement that I agree to with using the software. So this is not free software, even if someone gave it to me for free. Or for free gratis, I should say. So anytime I say free for the rest of this lecture, assume I mean libre, lack of restriction. Do not assume that I mean gratis. So anyway. Okay, so the GNU Project, we want to make a Unix-like operating system. So this was the start of the free software movement. And from there, they basically made the tools that make Linux possible. Linux is a Unix-like operating system, and there are, of course, free gratis versions, but all Linux systems are designed to be free libre. You can modify them however you want, you can redistribute them, you can improve them, whatever. And these are called the GNU tools. And from the GNU tools, we get the GNU public license. And the idea of copyleft as opposed to copyright, which I just realized I pointed right and then left when I said left and right. The point is, we're going to talk about what the GNU public license is and why it's copyleft, and why some people actually don't like that it's copyleft in a bit. It should note, the first thing is the GNU public license is actually rather restrictive, so much so that it created a backlash, and there was a response to it and a change. But first, What is the GNU public license? Well, there is a lovely Wikipedia article on this, and it's actually a really good article. I know that a lot on Wikipedia can be pretty not great sometimes, but it's actually a pretty good article. But what do we mean by the GNU public license being copyleft? Well, the idea of the GNU public license is that any software that is under the GNU public license, you are allowed to take that software and repurpose it, redistribute it, do whatever you want with it, add it to your existing system, but you agree that your software will also adhere to the GNU public license. That is to say, you can modify, the software can be used, modified, distributed in any situation that is under the same license. Which means if you build this huge project, and in some small part of the project you use some GNU library, your project is now can only be released under a GNU public license. And once it is a GNU public license, that's how it stays. And this can make it very restrictive because it's a viral license. Because if you build some software that builds on existing GNU library, your work is now a GNU library. Any work that uses your work is now a GNU library, or at least incorporates your work, is a GNU library. And examples of GNU software that exist are the Linux operating system kernel, GCC and G++, which are C and C++ compilers. Those are GNU software components. And so if you want to build something that uses these, you have to adhere to the GNU General Public License. That's what we mean by copyleft. If you use it, then you are also accepting the same licensing terms. So from there, we had open source as a response to the GNU public license. This was a term created in 1998, and this was in reaction to Netscape in that same year, announcing that they were going to release their source code. And there's kind of two broad categories. There's free open source, where all parts of the software are free. Again, free Libre. We're talking Libre. There's also commercial open source software, which is, if you think of a spectrum of, you must adhere to a strict end user license agreement versus fully free. Kind of in the middle, you have, some parts are free, some parts are proprietary. And those proprietary parts may be restricted, may not actually be considered free. And this often is used by companies that want to claim open source while still keeping some aspects of their code proprietary. So with that, a response to this was the MIT license, which was designed to be a license that was less restrictive than the GNU public license. It is very, very non-restrictive. There's three parts. Anyone can use the software for any reason. 2, the license must be included in the software, by which I mean, if you use that software, you have to mention that the license for this particular part of the program, so the whole of it doesn't have to be MIT, but the part of the program that you're using from someone else that's MIT license, that part must be MIT license. But not the whole program. It's not viral like GNU. But also there is no warranty, which is to say, if you use our software and it causes something to explode, that's on you. We're not promising that this software works at all. It comes with no warranty. Express or implied, as it were. And so examples of this are like Cake PHP or Ruby on Rails are actually released under the MIT license. A lot of frameworks are released under MIT, which is good because if your framework were released under GNU, then using that framework forces you to make your project GNU. And that limits what you can do. That's fairly restrictive as compared to MIT. So here's actually the language of the MIT license that you could put in your code. Copyright year, copyright holders. Permission is hereby granted, free of charge, to any person obtaining a copy of this software and associated documentation files to deal in the software without restriction, including without limitation, the right to use, copy, modify, merge, publish, distribute, sublicense, and or sell copies of the software. Again, free Libre, not free gratis necessarily, but free Libre, to sell copies, so you can sell software that uses libraries that are under the MIT license, for example. You can sell that, and that's fine. You don't have to make your whole project the MIT license. But the key is, this is the, but don't sue me clause. All of this is like, hey, if something breaks, it's on you. We don't promise this works at all. Which is kind of tongue-in-cheek, but it works. From there's the BSD license, and I should note that there's kind of 4 different clauses, and the 2-clause BSD license is rather similar to the MIT license. There's not a big difference. And in fact, BSD 2-clause, for example, is GPL compliant. It means that you can combine BSD 2-clause code with GPL code, and the whole thing is GPL. Going back, though, you can't necessarily do that with 3-clause or 4-clause BSD. You can't necessarily combine it with GPL code because the 3rd and the 4th clause of BSD are non-GPL compliant, as we'll talk about that. So something to note, the Django is released under 3-clause BSD. What are those 3 clauses? First, broadly, redistribution and use in source and binary forms, with or without modification, are permitted provided the following conditions are met. Redistributions of source code must retain the above copyright notice. This lists the conditions and following disclaimer. That's clause 1. Clause 2, redistributions of binary form must reproduce the above copyright notice, the list of the conditions following disclaimer in the documentation or other materials provided within the distribution. This may seem redundant, but there is actually a difference between the two. But the 3rd clause is neither the name of the producing organization nor the names of its contributors may be used to endorse or promote products derived from this software without specific prior written permission. That is to say, if I write a library and someone uses it to build a thing, they can't say, this has been endorsed by the bald guy, like, without me actually giving them permission to do that. And I probably wouldn't want them calling me the bald guy. Although that is the only interesting part of my personality at this point. So I'm not expecting you to memorize all these licenses, but at least be aware of kind of that viral effect of the GNU General Public License. I should note, there's technically General Public License 3.0 these days. From there, there's BSD. So, for instance, derived works must remain open. That is open source. If you publish something under GNU GPL, or GPL, that is the General Public License, if you publish it, that work must remain open. By comparison, BSD and MIT don't require that your code be open source. It doesn't require that it remains open. Can you change the license type for derived work? Derived work meaning some work that uses something under BSD or MIT. Yes, you can. Can you do that for GNU? Only if the owner agrees or you're releasing it under a compatible license. You cannot change to an incompatible license, however. That's important to note. So, all right, so what does this mean? What can you do with your project? Well, first, I want to introduce the licenses so you know how you could release a license for your software. But second, what can you do with your project? Well, the first is, if you build anything with the university, if you are paid by the university for the purposes of producing that, such as a graduate student or a paid research assistant, graduate student with a stipend that constitutes payment. A paid RA, you're paid hourly, maybe as an undergrad. Then the university owns your code. Sheriff and I are paid employees by the university. If we produce our code during time that we are working as an official professor at UVA, or if we use UVA hardware to do so, then the university owns our code. If you are not paid by the university as if you're not paid by the university, which most of you have not been paid, I imagine, for the projects you're doing, then you do own your own code, even if it's produced for the purposes of, say, a class, provided that you're not using university resource for it. Then you can release it, license it, sell it, whatever you want to do. For a group project, it's by default considered jointly owned by everyone who contributed to it, and you'd have to hash out any details in the incorporating process. And this is, I should note, our university policy, and it follows federal copyright law. So that's generally the gist here. But is your project really yours? Well, think about it. You didn't build Django. You didn't build Postgres. Any other libraries you use, say you use a Google Calendar library or a Google Maps library, you didn't build those. Right? Can you even name anything and keep records in your comments? So one thing you have to consider is what license are all of them released under. So we're going to do this class exercise on Thursday. We're going to look through the tools that you've used, and we're going to look at what licenses were they released. What does the license allow you to do as far as releasing your own work? Are there requirements for attribution? Are there restrictions on what kind of licenses you can use? So that's what we're going to do. So any copy left in there, that's something you'll need to consider for the guided practice. Well, Django is released under BSD license. But if you do have any code that was released under copy left license, of which the most popular is GPL, there are others, but GPL is the most popular, then you must release the entire system under GPL. Although there is LGPL, which, as we mentioned over here, that's lesser GPL. It's a bit separate. But from there, if you're developing real software for real customers, you have to pay attention to this. And as we said before, if you release under GPL, you cannot undo that decision because it's GPL forever. So, with that, that will be it. That's the last lecture video. We will still have a guided practice video, but I hope you enjoyed this class. I know I enjoyed teaching it, and I hope all of you have a great week and a great holiday break. I know we all need it. Saying goodbye for me and for Stooby Dooby Doo. Colby Bear has disappeared, but Stooby Dooby Doo is over there. Take care, everyone, and best of luck. Bye now.